Great. Well, thank you very much for your testimony. Are there any questions?
Madam Chair? Yes. Thank you all for coming. As you may have noticed, the First Amendment part of this debate is what interests me a great deal. My colleagues have done a great job at attesting to the other aspects of this. But so I guess my first question is to Attorney Curry. You said this is a content-based regulation. Is that quoting the NIFLA decision, or is that your own opinion?
As far as this regulation is concerned, I believe it is, in fact, quoting the NIFLA opinion.
Okay, so I have the NIFLA opinion here. I've read it. I didn't see that in there.
It cites the pickup case, which
the pickup
was,
case. Yes.
which
Great. The pickup
was,
case is the case in California in the Ninth Circuit where the court upheld a conversion therapy ban. Correct?
That's correct. It seems to me that in this decision, the Supreme Court is calling out that decision and saying that professional speech is not a category of speech they recognize. And throughout the opinion, the Supreme Court seems to criticize that decision and other decisions like it.
So I think I would agree in the limited sense, and I think even Attorney Klein mentioned this, that professional speech, that Justice Thomas did talk about professional speech in terms of just professional speech that was called out, as you say, by Justice Thomas. However, the pickup decision was based on professional conduct, incidental speech. Would you agree with that?
Yes, I do.
Would you
agree
also
with
agree that the Supreme Court had a chance to take up that case and declined to take it up?
At the time, yes, I do agree. But
Okay.
it's
Twice?
well, the landscape of speech has changed since then. As far as what the Supreme Court has been saying, they have not taken up the case. But if they did, we have serious concerns as to whether they would uphold
But they had the
that
opportunity
decision.
to take up a case and they passed on it.
That's correct.
And so you're basing the entire sort of pivot here is because of the NIFLA case. You thinking, is that changing the landscape? Because the landscape was pretty clear before that. Wouldn't you agree?
Well, the landscape is clear that the government does not have the right to restrict speech in any way, shape, or form.
Okay, but every time this has come up, there's the King decision in Third Circuit, pickup case. Every time it's come up, the courts have ruled that it is a fair regulation of professional conduct under the police powers of government licensing.
The Ninth Circuit has. That's
And
true.
every
I don't
other
believe the Supreme
circuit.
Court. I'm not certain that the Supreme Court would make
Okay.
that same decision based upon their criticism, very specific criticism of the decision and the reasoning in the pickup case.
I understand.
and
I'm sorry. I'm maybe sounding argumentative here, but when you made that claim, it kind of set me off because I think that's your opinion, and you're representing that as the court's opinion, which I don't believe is the case.
Well, if I may, this legislation defines sexual orientation to include homosexuality, heterosexuality, and there's another word in there, gender identity. But for example, this legislation doesn't apply to all sexual orientations. That right there is a content-based distinction.
This bill is very similar to the law in California. Would you agree that it's been upheld?
Yes, I agree with that.
Thank you.
Yes.
To place things in context and perspective, I'm actually from Liberty Counsel, the firm that represented David Pickup in that Ninth Circuit case.
I've seen that, yes.
And we've returned and asked for a motion to recommit, to change the mandate.
Too, February 11th, yes.
Right, both. February 11th is a very recent date, and it does represent, using the language that Thomas has provided in the NIFLA case, that it does open a new door to revisiting these decisions based on content-based content-based and viewpoint discrimination. So the door is wide open. Currently, we are litigating in Tampa as we speak today, where a magistrate has given us favorable rulings to continue promulgating this litigation. Absolutely.
Okay, and then the next week in Florida, another judge upheld the ban.
Which
Correct.
continues to demonstrate, as Attorney Curry was mentioning, the changing jurisprudence in the nation when it comes to this specific speech. One thing that does remain clear is that government has no place between a client and their therapist. It's not a place for government to insert themselves. But the Supreme Court and other courts across the nation are well within their rights to change legal jurisprudence. We've seen that Plessy v. Ferguson changed legal jurisprudence, Brown v. Board of Education. There are times when a court comes out with a decision, specifically language addressing a certain area of the law, that reopens an issue. And we're seeing that in the Ninth Circuit. We're seeing that also in the King case in New Jersey.
I'm just going to let that lie.
Excuse me. I do have one quick follow-up on this point around police powers. Can you describe police powers? Because it seems to me that what this bill in particular is doing is asserting the rights of the state around police powers to ensure that services that are provided are not causing undue harm to minors in our state. So I'd love for you to explain police powers and how you see the balance of the tension between what you're sort of focused on around free speech, which this bill is not really around. It's really a police power bill.
So I guess I'd be happy to answer that. So again, to specifically quote Justice Thomas in the NIFLA decision, addressing what he said is the flawed logic of the pickup decision in the Ninth Circuit and the King decision out of New Jersey, says speech is not unprotected merely because it is uttered by professionals. Doctors help patients make deeply personal decisions, and their candor is crucial. When the government polices the content of professional speech, it can fail to, quote, preserve an uninhibited marketplace of ideas in which truth will ultimately prevail. So, we believe there is ample hope that the Supreme Court, if this law is unfortunately passed, that it will end up in those federal court decisions and be overturned because it is overbroad and it impinges on the rights of families and therapists and clients to get the counseling they choose. And I just want to add, because this hasn't been mentioned yet, Senate Bill 70 is by far the most aggressive form of this legislation we've seen to date in our country. It labels talk therapy statutorily as child abuse and would require all mandatory child welfare reporters to notify the state of any mental health professional who uses this type of therapy, including those therapists who have a simple conversation about same-sex attraction or gender identity with their client. Parents and therapists simply attempting, for example, to help gender-confused children avoid hormone injections and feel comfortable in their own skin would become the subject of a Department of Children and Families child abuse investigation, which could result in the loss of custody because it adds sexual orientation change efforts to the list of statutory child abuse categories under Section 51A, which is where you get the 51A reports, which is how Justina Pelletier, if you remember her, was stolen from her family for over a year because of a dispute over medical treatment. And I can't imagine that this body would want to repeat that tragedy on any number of youth who are simply trying to find their truth for how they live out their lives.
Okay, just a quick.
Really fast, I promise. Massachusetts Family Institute is associated with Focus on the Family, correct?
Focus on the Family, Alliance Defending Freedom, and the Family Research Council. That's
And
right.
Focus on the Family and Massachusetts Family Institute oppose same-sex marriage
We do.
and oppose same-sex adoption.
We believe every child deserves a mother and a father, and that marriage is between one man and one woman.
So over the course of the last several hours, we have heard from opponents to the ban that you want kids and adults to be able to make these decisions and that you would support them in their right to make that decision. But I think, is it not important for us to know that the opponents of the ban, yourselves, oppose the option of marriage for LGBTQ individuals and oppose adoption for these same individuals?
Well, what we're seeing with the current status of the law on those issues is the new victims being people who are trying to live out their lives, like the cake baker in Colorado who almost lost his business because he was trying to live out his conscience. And I can't imagine you would want someone to violate their conscience on these issues, would you?
I need to stop.
Okay, thank you for your testimony, and we are moving on.